and various announcements of events that we're going to be having coming up. As many of you know, today's conversation is part of the University of Texas's celebration of Free Speech Week. And I did want to make our undergrads in the audience who are aware of this, or people who may have access to undergrads, that there is a free speech essay competition being held, and you can actually win some significant money for, I think, the top 3 essays. So those people who are interested in that will want to go to www.freespeechessay.com, and they can get all the details and most specifically what they need to do to earn some money. In just a second, I'm going to introduce our speakers, but I do want to emphasize, we want this to be a nice and robust conversation, and our hope is that our attendees can participate as well. So if you all scroll down to or look down at the bottom of your Zoom screen, you'll see a little Q&A feature. I'm sure you're familiar with that 7 months into COVID. What I'd love for you to do is, if you've got questions while Eugene and Nelson are talking, please put your questions in the Q&A feature. I will keep track of those, keep an eye on them, and do our best to pass them on to both professors, and hopefully we'll get as many addressed as possible. So with that, Eugene and Nelson, welcome. Let me, if you don't mind, I'm gonna make you both uncomfortable by introducing you and reading some brief bios, and then we'll turn it over to you to have hopefully a wonderful conversation. Sound good?
Great. Sure. Brief bios are always better.
Yes. Okay. Well, here we go. Nelson Tebbe is the Jane M.G. Foster Professor of Law at Cornell Law School. He's one of the nation's leading First Amendment scholars and teaches and has published widely on constitutional law, freedom of religion, freedom of speech, and the intersection between religious traditions and democratic governments. He is the author or co-author of at least 2 books on religious freedom and a multitude of articles in the nation's leading academic law journals. He is the co-organizer of the annual Law and Religion Roundtable and is a sought-after speaker and commentator across the nation. Eugene Volokh is the Gary T. Schwartz Distinguished Professor of Law at the UCLA School of Law, where he teaches First Amendment and a First Amendment amicus brief clinic, along with other courses. He too is one of the nation's premier scholars on the First Amendment. He is the author of 2 textbooks and over 90 law review articles. He is a member of the American Law Institute, a member of the American Heritage Dictionary Usage Panel, and the founder and co-author of the Volokh Conspiracy, a leading legal blog. His law review articles have been cited by opinions in 8 Supreme Court cases and several hundred court opinions in total, as well as by several thousand scholarly articles. So we are grateful and privileged to have you both here today. I think as we talked, we want this to be as conversational as possible. But we are going to start off with letting Nelson go first. What inspired the topic of our conversation today was Nelson's latest Cornell Law Review article entitled "A Democratic Political Economy for the First Amendment." So what we'd like to do is have Nelson start off by explaining a little bit about what his article is about, his arguments in there, some of his proposals. We'll let Eugene respond, and then hopefully from there, the 2 of you can play off each other. I'll send questions your way, and I'll monitor the Q&A so we can get questions from our audience. And with that, Nelson, please take it away.
Thanks. It's a total delight to be here. I wish I could be in Austin in person, but this is second best and a real pleasure. Steve, I want to thank you for inviting me to come speak with the university community. And I also want to thank Eugene for joining us. I've been reading and admiring his articles for a long time, and it's a real honor to be part of the conversation with him. So I'm interested in the relationship between the First Amendment and the just distribution of resources, including wealth and income. We're experiencing a historical moment of intensifying resource inequality, a widening gap between wealthy and indigent Americans. And at precisely that moment, freedom of speech and religion are being used to weaken redistributive programs. Other scholars have noticed this, and they've argued that the First Amendment is being deployed in a manner that exacerbates disparities of wealth, income, and other primary goods. While there's diversity of views among these authors, there's also a common sense that freedoms of speech and religion are constitutionalizing a political economy that works to worsen distributive injustice by unwinding government programs. And that's a critical insight. So I build on that literature by asking, is it possible to imagine a constructive relationship between the First Amendment and distributive justice? And I answer by building up a more inclusive conception of freedom of speech and freedom of religion, one that responds in specific ways to material disparity and deprivation. The key, I argue, to understanding the connection between rights and material conditions is a conception of democracy. In the project, I describe one such conception and its entailments. In brief, people who are suffering will find it difficult to exercise fundamental freedoms, and they'll be unable to participate meaningfully in the project of cooperative government. So liberties may become impossible to realize without sufficient primary goods, while membership status within the political community may be degraded by structural inequality of economic wherewithal. These problems can be avoided, at least partially, if freedom of speech and religion are construed in ways that are sensitive to and indeed demand the material conditions for their meaningful exercise. This approach is substantive rather than formal. It connects interpretation of the First Amendment to a conception of political morality and ultimately to distributional requirements that support the ability of participants to cooperate in a project of political authorship. So three caveats. I accept for now the priority of basic social and political rights over ordinary economic policy. An alternative would be to reimagine that relationship, but I don't do that here. Second, for purposes of the project, I also assume the traditional negative conception of rights while acknowledging the power and relevance of the alternative constitutional tradition of positive socioeconomic guarantees that's been elaborated, for example, by Joey Fishkin and Willie Forbath in their forthcoming book from Harvard University Press. And finally, I don't try to reinvigorate the idea of economic rights to liberty and property. So given those constraints, is it still possible to articulate a conception of the First Amendment that incorporates concern for the fair allocation of primary goods? I think the answer is yes. So I hope just in a few minutes, what remains of the sort of less than 10 minutes I hope to take to describe this project, just to identify three specific ways in which distributive justice is relevant to rights interpretation, though there are doubtless more, and just give examples of each. And I'm going to limit myself to speech examples because we're celebrating Free Speech Week here at the University of Texas. But in the paper, I give examples from freedom of religion as well. So first, democracy is characterized not just by rights, but also by duties. It features a social division of responsibility where government has an obligation to provide a just framework, but then individuals have to do their part to support that framework and must exercise any choices within it. So for example, people have a duty to pay taxes even where that makes it more difficult to engage in speech. Likewise, virtually no one thinks that adherents of religions that require expensive pilgrimages or heavy tithing therefore have a reason not to pay taxes that are otherwise just. The court's decision in Janus from 2018 seems wrong-headed from this perspective. That case concerned a labor law requirement that workers in a unionized workplace who declined to be members of the union, as was their right, still had to contribute an agency fee that was equivalent to a certain percentage of union dues. Without such a requirement, the government reasoned, workers would be incentivized to quit the union because they could still receive the benefits of collective bargaining without having to pay union dues. But regardless of that concern and putting it to one side, the Supreme Court invalidated the agency fee on the ground that it coerced worker support of union speech, namely collective bargaining and associated expression. But if the agency fee is part of the social division of responsibility, then the court's decision was mistaken. More generally, basic liberties do not entitle their holders to shirk their obligations to the very society that makes their liberties possible. A second way in which distributional concerns inform rights interpretation is this. It identifies a social minimum below which people will enjoy freedoms in principle that are worthless in practice. No one should be so destitute that they're unable to exercise their basic liberties or relegated to a subordinate caste. Democracy cannot function under conditions in which some of the people are rendered incapable or inferior. Government's obligation to provide the conditions for the meaningful exercise of individual rights and for meaningful participation in cooperative governance properly informs the interpretation of guarantees that otherwise would prevent it from maintaining those conditions. Now, interest in the social minimum, this second sort of specific way in which my argument is relevant, can affect constitutional interpretation in a wide variety of contexts. Labor law is one mechanism for ensuring that workers can support themselves by earning a reasonable wage. When courts or regulators undermine its provisions in the name of the First Amendment, they can discount or ignore the imperative of ensuring the underpinnings for meaningful participation in a democratic project. So examples of this are unfortunately kind of common. To take just one, think of National Association of Manufacturers against NLRB from 2013. There, the DC Circuit invalidated the notice posting rule. That was a requirement that employers notify workers of certain statutory rights. Because labor law requires workers to bring challenges to unfair practices, the government thought it was necessary to tell workers both that they had those protections and that they bore the burden of enforcing them. But the court disagreed, and it struck down the notice posting rule, reasoning that being required to post the information was compelled speech to the employer. But this frame of analysis fails to consider that the notice posting rule is part of a government framework designed to ensure that employees had the bargaining power to extract a decent wage from employers, a wage necessary to support the exercise of their individual rights and their participation in the political process. So third and finally, and I'll just end here, rights that are competitive in nature must have fair value, not weighted by economic or social power. Political rights are the classic example: voting, speech on political issues, insofar as they enable electoral contest. If some voices are greater in impact than others because of disparate resources or because of cultural domination, then the democratic process ceases to work well for any but a dominant few. And that means that people can't effectively safeguard their other interests against government incursion. Ideally, all people have an equal chance to inform themselves about the workings of government. They're able to deliberate and discuss what they learn with others, and they have realistic opportunities to formulate and convey their views. Citizens United, for me, is the central example. There, the court invalidated a campaign finance rule that regulated corporate speech. Justice Kennedy looked only to the categories that the statute deployed to find government unfairness in the form of content and speaker discrimination. But to view the speech right in that way is to disregard the broader political economy, in which legislation that uses content categories might promote rather than impede political liberties. In other words, the ability of all people to participate in the political that in turn is responsible for regulating the economic inequalities that produce fairness in the first place. An alternative approach would recognize the ability and even the imperative on Congress to counteract the unmistakable tendency of wealth and other forms of economic capital to translate into political capital in American electoral practice. In other words, there are expressive interests on both sides in campaign finance cases like Citizens United, and a democratic approach would recognize that. In sum, then, both the scope and the strength of the First Amendment must be understood in terms of a robust conception of democracy that recognizes the actually existing connection between economic power and political influence. So that's the argument of the paper, although there are lots of other examples there and other arguments indeed as well. But I hope that gives a fair sense to everyone watching of what I'm trying to argue.
Thanks. It's a very interesting paper, which I read, and a very interesting presentation. I think there's a lot to be said for that position. So to some things I actually agree. For reasons we may not want to get into here, I think that Janus was just wrongly decided, though I think it was part of a 50-year reign of error on the part of the court, both the left and the right, when it comes to compelled contributions. But let's just step back a little bit. What's the backstory behind the phenomenon, setting aside Janus, but looking at Citizens United and some Buckley v. Vallejo and such cases that Nelson describes? It's simply our assumption from our capitalist society, private property-based society, that constitutional rights include the right to use your property to exercise those rights. They don't include the rights to use others' property, except in very unusual circumstances, but they also include your right to use as much of it as you'd like. Let's just take an example. I have a right to send my kids to private school. The government doesn't have to pay for it. I mean, I think there are plausible arguments that would be better if the government paid for it through some school choice system, much as it pays for private college education through student loans and the like, or GI Bill and the like, but it doesn't have to. At the same time, I'm entitled to use my money to send my kids to private school. And if the government were to say, you can only use $1,000 a year to send your kids to private school, that would be considered a violation of my private schooling rights. Now, some people, especially kind of people who really have a radical, neutral, in a descriptive rather than judgmental sense, but a radical view of redistribution might say that's part of the problem. we shouldn't allow people to educate their kids privately because that exacerbates wealth inequalities. But generally speaking, this is how we've long understood rights. And the same thing is true about free speech rights. So this is part of the question. Should we continue to think that your right to speak, your right to contribute money to a church, let's say, your right to educate your children, your right to have assistance of counsel, should that continue to include your rights to use your own property in order to do that? So that's the big picture thing. And I think the answer is yes. And I think a related problem is when the government limits certain people's or groups' ability to use their property to exercise rights, it will very sharply diminish those rights and diminish a counterweight to its authority. So let's take another, just return to private schools, whether they're religious schools or secular schools. Might send my kids to a secular private school. Lots of people to religious private schools. They're a counterweight to governmental authority. Government spends vast amounts of money, on public schools, which promote the governmental line, governmental ideology. Now, of course, it's not uniform because in America, it's not set at the federal level. It may vary from state to state and even from school district to school district. But that's an important way the government exercises its power. And if the government were to, on top of that, be able to limit the escape hatch for some people, again, religious or non-religious, sending their kids to private school, that would further increase government power and diminish the power of one of the rivals to the government here. So that's the general big picture thing that I think is lurking behind here. You can like it or not, that principle. And I think Nelson's view is, well, your right to use your property for constitutional rights purposes should be limited in the interests of equality, at least in certain situations. We can talk about those. But that's what I think is the heart. Those two things, the right to use your property and the skepticism about government limits on that right when it comes to constitutional exercise of constitutional rights, I think that's what's going on. But let's get concrete. I found Nelson's article very interesting, but unless I am mistaken, and maybe I am, I'd be happy to be corrected, I think it was one word that was almost entirely missing from it was press, right? I think it's mentioned in a footnote where it talks, it just quotes a case that talks about freedom of speech and of the press, but doesn't really discuss the fact that throughout American history, one of the most serious inequalities of economic power, leading inequality of political power, has been the fact that newspapers and magazines and TV stations and such, but especially newspapers, have had extraordinary and continue to have extraordinary influence, far greater than any of us. Is the influence of the publisher or editor of a newspaper. That is without doubt a form of inequality. It's a form of inequality people have complained about. So one question I'd like to ask Nelson is, what would he think about a way of trying to level the playing field by limiting newspapers' authority to comment about candidates, for example, to editorialize for candidates, or perhaps even more influential is the newspaper's authority to pick and choose which stories to cover. Maybe an editorial about a candidate people will just dismiss, but if they cover the candidate in a positive or negative way in their news pages, that's something that might influence people a lot more. So I'd like to know whether Nelson thinks that this sort of economic equalizing, leveling project should also extend to newspapers and the like. Now, to be sure, there's been some degree of equalization just as a result of the operation of the market and technology. It used to be that in many cities there was only one newspaper and then a handful of national newspapers potentially available, but very hard to get, especially same day. Now people can access all sorts of newspapers from all over the place, although if they want news about their locality, it may be more limited. Likewise, there are many more rival kinds of sources from cable news networks and the like. Nonetheless, unsurprisingly, the most powerful such sources tend to be the wealthiest ones. And that includes, even with all of their economic problems, the newspapers, broadcasters, and the like. So that's one question I wanted to ask Nelson. Second question I wanted to ask Nelson has to do with the wealthiest of them all. And of course, we've seen this in the news a lot recently. What about Facebook? What about Twitter? Nelson, what would be your view of attempts to, for example, not just provide net neutrality, that goes to that actually would benefit, say, the Facebooks and Twitters of the world and limit the authority of cable companies. But what would you say about some of the proposals we hear that says, Facebook and Twitter shouldn't be able to block material that is posted on it on the grounds that it thinks that it's hateful, or that it flows from unsavory sources, or that it's supposedly fake news, or whatever else. But what's more, since I think your proposal isn't just about restrictions on property owners' ability to exclude, but also restrictions on property owners' ability to use their property to speak. What about a rule that says, Facebook and Twitter, we don't even want them to opine themselves, put a little thing saying, we think this is fake news, we think this is hateful, we want to warn you about it. Because again, if you're looking at a disproportional power, surely that's among the greatest sorts of exercises of disproportionate power in American history. And the third question I wanted to ask, and of course we'll have plenty of time for more questions as well, but the third question I wanted to ask, because things come in threes, right? Holy Trinity, life, liberty, and pursuit of happiness, three things. The third question is, Citizens United and Buckley famously involved laws that tried to level the playing field, so to speak, as the metaphor goes, when it comes to speech about elections. But of course, speech about elections is not the only thing that influences elections. Speech about the issues influences elections too. In fact, perhaps a lot more so. So, Nelson, what would you say about proposals not just to reinstitute the law struck down in Buckley, which, remember, limited anybody, individual, corporation, whoever else, to $1,000 in spending in order, if they wanted to speak out for or against the candidate? What about laws that limit people's ability to speak out about issues? Could be about global warming, or it could be about race relations, or whatever else. If it's unfair that rich people have, and probably not just rich people, right, but rich organizations, rich corporations, probably rich nonprofits, rich religious groups. Religious groups and nonprofits generally don't have the power to speak out about candidates, because at least not using tax-exempt funds, but they surely have the power to speak out about issues. So what would you say about attempts to level that playing field by prohibiting people from spending more than $1,000 to express their views on any issue, whether it's a candidate or a ballot measure, or just right and wrong in a way that might affect an election?
Thank you, Eugene. Nelson, I think our host will try to unmute you in just a second as you go. Just so you all know, when you mute yourselves, it's possible that you may need help unmuting. So if you have a problem, just wave hysterically.
One-way ratchet.
Yeah, that's right. I hear three wonderful questions from Eugene that all to me seem to relate to how do we cabin some of this doctrine that you've been proposing, or these doctrinal suggestions that you have given us, Nelson. And I'd love to hear your thoughts on the questions that Eugene asked.
Yeah, that's great. I actually kind of forced, maybe you're less Trinitarian than but in any event, a lot of great questions. And thank you, Eugene, for taking the time to look at the paper and consider it carefully. I appreciate it. I agree with a lot of what you said. I mean, I think there do have to be limits, and drawing those limits is an important kind of project. And some of the traditional concerns of the First Amendment are relevant in these areas that we've been discussing. Concerns about government distortion, about censorship, about viewpoint discrimination. Like these don't go away under the kind of regime that I'm describing. So I guess, so I'm sympathetic to a lot of what you say, and I think a lot of this has to be worked out. Your questions are, quite like on the ground practical questions, which is fair, because this project is, trying to make some moves theoretically, but also trying to apply them to real world difficulties and cases. So I think that's totally fair. Stepping back on the big picture, and I took it to your first point before you even got into specific.
Step zero.
Step zero. All right, zero. Good, that preserves the Trinitarian.
Exactly.
Comment before you do that, we did get a comment from one person in the Q&A saying that we all have to remember many of our audience are going to be lay people who don't know Supreme Court cases by name and are not, inherently just fluent in this language. So everything we can do to help this be phrased like you might do on television for a lay audience, the better. And then you can go ahead and
Good point.
Right, because we're speaking to the whole university, right? Not just lawyers and not just law students.
Correct, and not just law faculty. So
right. Look, I mean, if you step back and look at the big picture as you invited me to do, Eugene, it's true that we have a capital system, but we don't have an unalloyed capital system. We never have had. It's never been a system of pure sort of laissez-faire capitalism. And So while I agree that it does make sense to kind of step back and think about, what are the restrictions on the rights to property and the rights of citizens to use property to speak that we tolerate, well, we have a long tradition of tolerating some restrictions on those kinds of abilities. Taxes are the big one, right? Citizens have a duty to support the government, and that's true even if they would otherwise use that money to speak. It's true even if they would otherwise use that money to practice their religion, right? I mean, these are crucial interests of private citizens in a democracy, and yet we don't say you can do whatever you want with your money with regard to the exercise of fundamental rights or other kinds of activities. So that's one place. Another place is on the level of extra federal free speech law. So although shopping centers do have rights to exclude speakers under federal law, under lots of state law that's not true, and the Supreme Court has tolerated state laws that require property owners, shopping center owners, to allow speakers onto their territory. Another is the fairness doctrine, right, which required kinds of media companies in certain kinds of media genres to allow speakers access to their businesses and their publications in order to engage in certain kinds of counter speech. So I guess in the picture, I see a much more complicated and rich picture than some kind of simple capitalist design. I'd also say that, one of the, again, just on the big picture, one of the sources of limitation for me is that not all my proposals are egalitarian, meaning they don't all require equal resources to do everything. In key respects, this proposal is sufficientarian, meaning people need to have enough. It trades on a basic kind of impulse that it's really not okay in a democracy for people to be so deprived of primary goods or basic resources such as wealth and income that they can't even participate in the democracy, either because they can't exercise basic freedoms like the freedom to vote or to inform themselves on matters of public concern, or to voice their opinions on those issues and deliberate on them with others, or that they're relegated to a subordinate kind of caste because they're experiencing extreme forms of deprivation. Those types of insufficient primary goods, or those circumstances, are not compatible with the meaningful exercise of basic freedoms that make the democracy possible in the first place. Maybe I won't talk about your specific questions, although we can talk about them afterwards, because I want to leave time for people to ask questions from the audience. But I do think that your question about the press is a really interesting one, and newspapers in particular, because with respect to newspapers, we've never had a fairness doctrine exactly, and at least not one that's been supported by the Supreme Court. And you might think like the antidote to powerful newspapers who are able to formulate views and broadcast them with extreme effectiveness isn't to silence those newspapers, but instead to imagine government programs that would subsidize alternative kind of newspapers. And those, I think, would be wonderful. It would be great if the government could do more to equalize and enrich the speech environment by subsidizing newspapers for those people who lack resources to otherwise promote them. I don't think that would impair on any of the kinds of concerns that you rightly raised with respect to newspaper publication, but it would greatly ameliorate the kind of situation that I'm worried about. Facebook and Twitter are, I hope we have time to talk about this more, because I agree with you, this is a very difficult situation. Here you have two entities, and more if you include Google and then all the companies that Facebook owns, like Instagram and Messenger and so forth, that began as kind of fledgling experiments in democratic participation and availability for all Americans, and indeed for all citizens of the world, but became kind of engines of the second Gilded Age. They now are monster corporations with incredible resources, and suddenly the use of those resources becomes a pressing matter of public importance. Unfortunately, though, the solutions aren't totally obvious, at least to me, because some of their practices I think rightly support imperatives to sort of help communities that are otherwise marginalized or suffering from subordinate citizenship status, and helps to protect them against, for example, speech that would further marginalize them on these platforms. I don't think it would be wise to sort of make that illegal. It might also be unconstitutional to do that. On the other hand, these platforms do exercise outsized kind of influence over the speech environment, and they're able to construct the speech environment in ways that ought to give all Americans pause. So I think we need to have a serious national conversation about laws like Section 230 of the Communications Decency Act, which immunizes these huge platforms from civil liability across all range of issues, not just defamation, but civil rights litigation and so forth. It seems like there's actually bipartisan support for kind of constraining Section 230. Where we disagree is like, what would those constraints look like? What exactly should we do about the outsized influence of these economic and political behemoths on a national election like the one we're about to have?
So that's all great. Thanks very much for your reaction. I take it we're going to shift to questions soon, but I just wanted to briefly note a couple of things about the way that this discussion has been going. Back in 2003, I think, I published an article called Mechanisms of the Slippery Slope. I've always been very interested in slippery slope arguments. Of course, they're commonplace in rights discourse and elsewhere. People often sort of poo-poo the others' arguments while making their own. Certainly, there are plenty of such arguments that are made with regard to speech, but also gun rights, abortion rights, privacy, and the like. But one of the things that fuels, I think, that makes the slippery slope a real thing is the way that we use analogies routinely in a legal system and perhaps a mental system that we have in our brains that are based on precedent and analogy. So note, some of the examples that you gave. So you pointed out that we have taxes, which of course take away some of our property and limit our ability to use that property for all sorts of things. But even if somebody's in the 50% aggregate federal and state tax bracket, pardon? There you go. I think that's a much more minor burden, serious as it is, than on your free speech rights, than saying you can't spend more than $1,000 to speak. It's one thing to say, look, we're going to take half of your property for all sorts of things, some of which you're going to get some benefit for. But then the remainder, however much you have, and presumably if we're in the 50% tax bracket, we've got a decent amount left, you can use for whatever you want, versus saying, well, we're going to use that as an analogy to say, and on top of that, whatever we don't take, you can spend at most $1,000 of it in order to express your views about Trump or Biden or whatever else. Likewise, another analogy is restrictions that the court has upheld in cases like Pruneyard on the ability of shopping mall owners to kick out speakers. So it's true that under the laws of about half a dozen states, shopping mall owners, even though they're private entities not governed by the First Amendment when it comes to their visitors, have to allow visitors reasonable access to a large shopping mall in order to leaflet or gather signatures or whatever else. But one of the rationales the court gave in upholding that is, well, of course, this law doesn't limit the shopping mall owner's ability to speak itself, presumably because it's got lots of other property there which he can use to speak. But now that's being used as an analogy to justify restrictions that do limit the ability of businesses, including shopping malls, to spend more than, say, $1,000, or as to corporations, perhaps spend anything in order to speak about elections. Likewise, with the fairness doctrine, which for all of its flaws, and there are very many, was supposed to be quite limited, now we see how the analogy goes. So one question I might ask you and others as well is, if we were to adopt a more radical leveling vision of the First Amendment, what other analogies would work from there? So one example that I gave is, once you accept the notion it's okay for the government to limit people's speech to essentially what you can buy for some amount of money, when you're speaking about elections, it seems pretty easy to then analogize when you're speaking about any issues that might be relevant to elections. So that's, I think, the point about slippery slopes and precedents that would be set. Let me mention just one other thing. So I appreciate your engaging the newspaper question, but note your response is, when Newspapers have a lot of power to speak. The government should spend money in order to boost rivals, maybe public radio or something like that. By the way, it would have to be a lot of money to make those rivals viable. Maybe less today in the internet age, but probably not. Whereas when it comes to me, just as take an example of somebody who, and actually let's set aside my media hat. Imagine I didn't have a blog. Imagine I wanted to
say, what do you mean? You're a media tycoon.
Right. Imagine I wanted to spend more than $1,000 or today more than $3,000 to put up an ad about the election. You're not saying, oh, well, we should let Volokh speak, but we should provide public financing of elections. Maybe you agree with that, but you wouldn't limit it to that. So for some reason, certain speakers under your model, newspapers, ought not be restricted, but instead there ought to be maybe other ways of trying to influence public, sort of promote a variety of views in public debate. Whereas other speakers, non-newspapers, they should be restricted to at most some amount of money. So that makes me a bit uneasy. So I don't know if it's time for questions or for you to respond and for whatever else, but that's my thinking on the matter.
I'm happy to take questions. I mean, slippery slopes are dangerous. As you say, though, they're used by everybody. And then there's a classic response, right? Guido Calabrese taught me this in torts class when I was in law school. And the classic response is not while this court sits, right? Meaning like there's always, you could always draw lines. They're both bad arguments.
That's such a great line because in 1950, pretty much at the start of the court's engagement with the restrictions on speech of communists in American, I think it's an American Communication Association versus Dowds, where the court upheld the law banning, it's essentially, in effect, banning labor union leaders who are communists from being labor union leaders. The court responded to the argument that this could be the start of a broad attempt to suppress communist speech with the line, quoting the line, not while this court sits. And the end of the 50s, in 1959, in Barenblatt, Justice Black, who'd always been a dissenter throughout all this, said that basically in 1950, he predicted all of these other restrictions on not just high-level union leaders, but all ordinary people who are viewed as communists or communist fellow travelers. And then he said, and yet the court still sits. And I think that was a very powerful effect, that the court may offer assurances. Well, of course, we'll draw a reasonable line. We've seen lots of situations where that has not happened.
Let me throw out a question there from the Q&A, and I guess Nelson, I'll throw it to you first. But I think some of our listeners are struggling to understand how free speech relates to what you've called distributive justice. So some are saying it seems like you're in favor of just redistribution of wealth more generally, but it's not clear how free speech is coming into that. I think what I see between the two of you is a disagreement, especially as it relates to regulation of political speech and this Supreme Court case that all of us refer to as Citizens United. But Nelson, perhaps you could flesh out a little bit your practical explanation for why you feel like certain interpretations of the free speech protections are somehow preventing people from having the resources they need to participate in a democracy. If I understand your argument, that's kind of your concern, is that some people simply don't have the material means to truly participate, and certain interpretations of free speech are contributing to that. If you could flesh that out a little bit, I'd appreciate it. And then I'd love to hear if Eugene disagrees at all.
Yeah, sure. I'm happy to do that. Look, this is a literature that pre-existed the article, and that the article is trying to build on. So if you reject parts of this critical literature, then you're gonna like less about my argument than you would otherwise. But the idea is that the court has been using the speech clause, and I would add also the free exercise clause, although we can leave that to one side, to strike down government programs that are designed to ameliorate in various ways unequal distribution of primary goods, not just wealth and income, but healthcare resources, educational resources, environmental fairness, and so forth. There are lots of examples of this, but one that I give in the paper, but it's not, I didn't invent this, is the Sorrell case, where Vermont had instituted a program that prevented the use of data mining to engage in certain targeted marketing practices in the pharmaceuticals industry. So the government had a rule that pharmacies had to collect information about people who got filled prescriptions in their pharmacy. And that created a lot of data about not just patients, but also about doctors, and which doctors were more likely to prescribe name brand drugs rather than generic drugs. And then that information was then sold to pharmaceutical companies, and the pharmaceutical companies could use this data to target individual doctors. And then they'd send people out in the field, like actual sales to these doctors' offices, and kind of get them to prescribe the drugs that they were selling. And Vermont said, this is a problem. Like, it's not only a problem for privacy, although it was a problem for privacy, but it's also a problem for the political economy, that is the fair distribution of resources, because generic drugs are in many cases cheaper for patients and just as effective. So if this marketing program is effective, and the drug companies thought that it was, in getting physicians to prescribe name brand drugs at higher rates, that'll help the profits of drug companies, but it's not going to help ordinary people. In fact, it will further erode their economic circumstances, and also their access to what I call primary goods, like a catch-all phrase for not just money, but the basic necessities that people require in order to exist in a day-to-day way in the society. And the Supreme Court struck down this Vermont law on free speech grounds, saying that it constituted discrimination on the basis of speaker identity to single out for-profit drug companies for kind of special regulatory burdens in this area, when that same data could continue to be used by the government itself for research purposes and so forth. So just one example. Citizens United is another, NIFLA against Becerra is another. All these cases where the government is trying in various ways to counteract the disparities that are not only exist in our society, but are growing at historic levels through various kinds of, and the court is striking them down using its power of judicial review under the First Amendment, and heedless of not only separation of powers concerns, but also many of these are state laws.
So the federal government and the state government, the government has tremendous power to do whatever the majority wants it to do. It has the power to wage war. It has the power to wage the war on drugs. It has the power to redistribute resources. It does redistribute resources through the tax system and through various other means. Its power is immense. If it wanted to, for example, it could say, we think that people should have a voucher to speak. Like, we want to make sure that people have some money, even poor people have the money to speak. So we're going to give them money that they can use in order to buy advertisements if they want to, or get internet access or whatever else. So it could do that. It could say, we think generic drugs are much better, so we're going to say that doctors must prescribe generic drugs, or maybe that pharmacies, when they're given a prescription for a drug, have to provide the cheapest available one. And if the generic is equivalent to the non-generic, then that's what they should do. Perfectly free to do that. But the court has said the government has to exercise all of these powers, for example, fighting drugs or fighting a war, whatever, consistently with the Constitution. So the government can ban drugs, can send people to prison for using cocaine, let's say, or buying or selling cocaine. But it can't try to accomplish this by, for example, saying to people, you can't write pro-drug articles, or you can't criticize the war on drugs, or the war in Vietnam, or whatever else. Likewise, it seems to me, in these kinds of situations. In Sorrell, the government, again, could have said, we don't want doctors to prescribe non-prescription drugs, or they can prescribe whatever they want, but the pharmacy should to prescribe non-generic drugs, should fill that prescription of the generic drug. It could do that because that's not a speech restriction. But the way that it did it is by limiting the ability of drug companies to communicate certain information that they gathered from various available data in attempts to try to persuade doctors. And the Supreme Court has generally said that that's impermissible. Now, you can argue whether the court was right or wrong on Sorrell, but we're not asking whether the government should have the power to redistribute rights or redistribute property, or try to make things cheaper for poor consumers. Of course it has that power. It exercises it very often and could exercise it more if it had the political will. But the question is, what can it do by way of restricting speech in order to accomplish those goals?
So Nelson, I hear Eugene saying that the government can achieve some of these goals that you're talking about wanting to achieve, but doing it without regulating speech. And it sounds to me like you two might have a disagreement on that. Perhaps your disagreement is that people defending against these regulations are expanding the scope of free speech, of the free speech clause, to try to defend themselves. But I'd love for you to flesh that out if you disagree with what Eugene just said, or if you have other thoughts on it.
No, I mean, I think Eugene is right to sort of, keep coming back to the fundamentals of speech law and how it relates to the basic ways in which we think that the government can permissibly redistribute opportunities in our society. The problem is that, as I said, Steve, the court seems to be expanding the category of what counts as speech. I know Janus is one case where Eugene is worried about that too, but Sorrell is one where that seems to be happening to me. And this was about data mining and marketing on an individualized basis to doctors using data. Like it's hard even to understand how speech is involved at all. And yet the court seems to be expanding the scope of the speech clause in ways that allow it to invalidate more and more programs that seemingly have very little to do with the basic principles that Eugene is setting out. NIFLA against Becerra is another example of that. There you have the state of California saying, we're worried about crisis pregnancy centers. What are crisis pregnancy centers? These are nonprofits run by religious organizations that advertise, they market to pregnant women who are worried, who have become pregnant through an accident. And the ads say stuff like, are you worried? You just became pregnant. You don't know what to do. Come to us, right? And the state of California, like what they would do is persuade these women not to abort their pregnancies, but instead to carry their pregnancies to term. And they do that for religious reasons. They have deeply held beliefs that it's immoral and sinful to terminate a pregnancy through medical means. And so instead they encourage these women not to do that. And the state of California said, look, we're worried about market effects. These are mostly indigent women. Many of them have limited access to English. They're from otherwise marginalized populations, and they don't know that when they look at an ad and follow the advice of the ad by calling the number and visiting the center, they don't know that they're not visiting an abortion clinic. They think that they are that they're visiting a clinic that offers all services. So the state of California, implemented a statute that was relatively modest. It just said, you just have to post the information for these women so that we can sort of counteract at least a little bit the worry about deception. And just say, if you're a licensed pregnancy center, you just have to say, there is access to other services that can help you if you want to terminate your pregnancy and exercise your constitutional right to reproductive freedom. And if you're not licensed, the notice just had to say, this is not a licensed center. And the Supreme Court struck that one down also on free speech grounds, saying this was compelled speech by the state of California. There too, there's a predictable and obvious kind of redistributive effect of both the law that California was passing that was quite conscious on the part of legislators, but also the Supreme Court's decision to strike it down on speech grounds. It's doubtful whether that would have even been considered a case involving speech a generation ago. So you see, the worry is that the court is kind of achieving political sorts of goals that it wouldn't have been able to achieve in the legislature, but it's using the speech clause to do that, and in a way that insulates those decisions from from political correction through the democratic process because they're based in constitutional law. So, I guess it is, I would say it is the case that the speech clause is being used in ways that don't really track this kind of division between, on the one hand, the court protects constitutional rights, on the other hand, the government can redistribute through taxation and spending programs.
So Nelson, I'm just not sure how that argument is factually accurate. So let's look at Sorrell v. IMS Health. The law barred pharmaceutical manufacturers from engaging in certain marketing practices. Not, by the way, marketing to the public, but engaging in marketing practices to doctors.
Can I interrupt you here? I don't think it did that. It was about the sale of data. It wasn't a prohibition on marketing. It was a prohibition on the sale of data.
I'm just reading the court's summary. The law prohibits pharmaceutical manufacturers from using the information for marketing. And as to, so it restricted the ability.
I think the mechanism for that was a prohibition on the sale.
Well, they certainly had the prohibition on the communication. There was also a prohibition on communication, seems to me. But as to the sale of data, the sale of data is conveying information in exchange for money. The Wall Street Journal used to at least print information about the stock market for the benefit of the public in exchange for money, right? That is that's communication of information. And if you try to restrict that, that's restricting speech. It's restricting the communication of information. I think that using data as a label that's somehow the opposite of speech, it seems to me is mistaken. Much speech conveys data. It could be a single item of data, like in Florida Star v. BJF, as to the name of a rape victim. It could be the price of pharmaceuticals, as in the Virginia pharmacy case from 1976, I believe. Restricting the communication of information, it seems to me, is the speech restriction. As to NIFLA, the difference between NIFLA and other restrictions, and by the way, I could certainly see how one might say that should be an important difference, is NIFLA involved the compulsion to put up signs that say certain things on your property. That is long been understood, by long I mean at least since the 1970s, as a speech compulsion, that requiring a speaker, and by the way, that was an ideological speaker. It wasn't just like a shopping center. These were organizations that were set up in order to convey particular views about right and wrong and about what one should do with one's body. Requiring a speaker to include on its property a message that it might think is quite evil. Woolley v. Maynard said you can't be required to have a government prescribed message on your car. That is in 1978. That had to do with a license plate. A mandated license plate with a particular slogan. In 1988, Riley v. National Federation of the Blind, an opinion by Justice Brennan, the court struck down a requirement that fundraisers, and there they were trying to get money as opposed to NIFLA v. Becerra, that fundraisers indicate just one piece of data, and that is how much of the money that they're raising is going to go to the charity. And the court said that is an unconstitutional speech compulsion. Now, again, maybe the court made a mistake on that. Maybe we should say that compulsions of speech, because they increase what's available in the marketplace of ideas, should be viewed more leniently than speech restrictions. It was actually largely the work of Justice Brennan and other liberals in the court to draw this equation, but maybe they were mistaken. But I don't think there's any doubt that what's being compelled in NIFLA v. Becerra is the compulsion of speech, compulsion of posting a government prescribed message in the property of an ideological organization.
No, so I looked up Sorrell, and you're right. It was a prohibition on sale, but also on the use of the data to market. So that's right. But even if we grant that these are exercises of speech, and so just as Steve was saying, the kind of expansion of the speech clause into areas where it wouldn't have been involved in the past, kind of the point of my project is to say that shouldn't end the conversation, right? We should continue to think about the relationship between the fundamental right to freedom of expression and distributive justice in ways that don't simply say like, okay, this is speech, so then we stop talking, right? And then we understand the relationship between distributive justice and speech. And here's how that relationship has traditionally been understood. Distributive justice is something that's accomplished through ordinary legislation. As you say, like the government can do this at any time in lots of kinds of ways. If it wants to do that through ordinary legislation, it can. Once it trenches on speech or a fundamental interest like that, then the court gets involved and can exercise judicial review to undo the kinds of regulation that the government is engaged in. But the whole point of my project is to say, like, we really need to think about that relationship in more complicated ways. When in NIFLA against Becerra, the court strikes down and makes it just impossible for California to engage in this kind of regulation, it does impoverish the speech environment. It means that there's less information available, and deception is easier to effectuate against exactly the populations that are sort of most affected by the disparities of the second Gilded Age. That's the kind of conversation that I want to have. And I think you can have it even after the point of the analysis when you say like, okay, speech is involved, like this is compelled speech.
Well, we have, let me ask you two a question. We have one more great question. We're at our time, but I'd love to take 5 more minutes to hear your thoughts on it as kind of closing remarks. Is that okay with both of you?
Sure.
And hopefully our attendees will stay with us. So somebody asked the question that the government has repeatedly bailed out large companies that carry a lot of power through the Federal Reserve, thereby increasing inflation, which hurts those at the bottom of the wealth scale more than those at the top. So the question for you both would be, do you think limiting the government's ability to make these bailouts and endlessly raising inflation would better achieve the redistribution goal and promote everyone's ability to exercise their free speech at the same time? I like this question because I think it gets at a little bit the heart of this. Nelson, you're talking about what are the baselines and what is the underlying background world we live in when we make these assumptions about these speech cases. This question kind of gets at the heart, I think, at those questions. Are there other regulatory maneuvers that could be made to help achieve your goals other than looking at speech? Why don't we do, Eugene, why don't you respond to the question, and then we'll let Nelson have the last word since it's his wonderful article, and then wrap it up, and maybe just a couple minutes each.
Sure. I can't speak to the economic theory in the questioner's question. Maybe the bailouts do cause inflation, maybe they don't. It's an interesting question, who benefits more from inflation in certain kinds of situations. Certainly we've had a situation where in 2008, there were quite substantial bailouts, but apparently not very material inflation. So I don't know what the answer is, but that's one of the, I think, the ways the First Amendment doctrine and Bill of Rights doctrine more generally operates, which is we don't know what the answer is. If the government wants to provide bailouts, or if it wants to prohibit bailouts, or it wants to raise taxes, or it wants to regulate in various ways, it has very broad authority. It just has to exercise that authority consistent with certain relatively modest limits. If it wants to fight the war on drugs or wants to fight hate crimes, it can do so. But it can't just say, but it's just too hard to do it with juries. Juries are just too cumbersome, too expensive, too likely to acquit. We're just going to do it without juries. No, you just can't do that. You can accomplish your goals, but subject to constraints of the Sixth Amendment. Of the Fourth Amendment. Now, Fourth Amendment has an inherent reasonableness balancing built into it, and as a result may have been read more narrowly, maybe more narrowly than it should have, but still, it's an important constraint on what the government is doing. Likewise with the First Amendment. So if you want to redistribute wealth in lots and lots of ways, you are free to do that. We can vote for that, or we can vote against that. There may be economic constraints on that. If you redistribute wealth too much, then people get an equal size of a much smaller pie, perhaps. But you just shouldn't be able to do that in a way that restricts people's constitutional rights. That's the whole point, is that of the Bill of Rights, is to subject all of the powers of the federal government and the 14th Amendment of state governments to these constraints. So that's the way that I would view things. It doesn't answer some of the specific questions, but it just reminds us there are lots of other ways of trying to deal with the problems that Nelson said.
Nelson, last word.
Yeah, it is a great question, but like Eugene, like I'm just not like qualified to sort of get into the details of the interest rate sort of environment and how that affects people's ability to speak. But I will say that, I mean, I agree with everything Eugene said, but I will say that, you know, some of the solutions to the problems that we've been discussing today might be kind of structural in that way. So for example, Facebook and Twitter, you know, part of the problem is that they have such outsized power speech environment that has economic consequences and also consequences for political discourse. So structural answers might include, you know, breaking up those companies, that is diffusing that power, so that the kinds of networks that they enable could compete with each other and allow people choices of the sort of speech environment that they might prefer. You know, as Willie Forbath and Joey Fishkin of your faculty are showing in this important project, arguments for antitrust kind of measures like that were associated with the Constitution for much of our history through the 17th, 18th, 19th, and early 20th centuries. There was a connection between kind of structural reform like that, the democracy that we kind of envision and hope to achieve, and constitutional guarantees. And I guess so one thing I'm trying to do in this project is to kind of make those connections alive again for readers.
Wonderful. Well, we'll have to leave it there. We're out of time. I want to thank both of you for taking the time to do this. It's just been an absolute pleasure for me. I could have gone the rest of the day just talking with you about this. So thank you, Nelson, for the article. Thank you, Eugene, for your wonderful thoughts, and look forward to connecting with you again another time.
Thanks, guys. Thank you very much.